Good morning, everyone, and welcome to our presentation. Today, our group is going to examine how the courts have served as the guardian of fundamental rights through the use of the rights-based conception of law within the judicial review process. Good morning, everyone, and welcome to our presentation. Today, our group is going to examine how the courts have served as the guardian of fundamental rights through the use of the rights-based conception of law within the judicial review process. First of all, what is judicial review? Judicial review represents the means by which the decision-making process of the executive can be scrutinized and declared to be unlawful by the judiciary. Judicial scrutiny of executive action is an important component of a functional separation of powers because it ensures that no one branch of the state can abuse its powers and can be seen as the guardian of fundamental rights by using a rights-based approach in assessing a judicial review. As categorized by Lord Diplock in the Council of Civil Service Unions and Minister for the Civil Service, which is also known as the GCHQ case, there are three grounds for judicial review, which are illegality, irrationality, and procedural impropriety. Since the incorporation of the European Convention of Human Rights into Human Rights Act 1998, there is now a fourth ground of judicial review, which is proportionality. Before considering the proportionality approach, the means in which the court had adopted the rights-based approach at the earlier stage of judicial review prior to the establishment of proportionality will be discussed. However, this must be balanced against the limitations that the judiciary accepts upon its powers of judicial review and the challenges that the individuals face in bringing a claim. Hence, some of the potentially problematic areas will be evaluated.
Good day, Dr. Tamara and my friends. Today I'm going to talk about illegality. There's a possibility for errors to occur in administrative procedure when it comes to the time when the authority exercises their power of discretion. Illegality simply means the authority had acted outside of his granted power by the parliament, and by that, infringed the fundamental right of humans. Addressing the issue of illegality, we need to examine when illegality might happen. Illegality might happen when the decision maker has acted in outer virus, misunderstand or misinterpret the law or the fact, used its power for the wrong purpose, take into account of irrelevant consideration while ignoring the relevant one. Fifth, incompatible with ECHR. However, the above mentioned is not exhaustive list. Some example of the simple ultravirus are Fulham Corporation and Ex parte Vietnam. Moving forward, an error of law might appear in various forms. It could be that an authority misinterprets the law. You can see that in Tower Hamlets case, or the decision made by the authority was so erroneous that it does not make any sense in law, which is an Nisminic case. In comparison to the error of law, the courts tend to be more reluctant to review an error of fact. The court will only review an error of fact if it is special in some way, such as it's a precedent case or it is lacking of support evidence, which is Ashbridge Investment Limited. The case of Tan Thi Lam illustrated that when it comes to individual rights, the court prefer to adopt an approach that has the effect of delimiting those rights. A decision made by an authority may also be illegal if it was used for the wrong purpose. This can be referred to Congreve and Porter case. Speaking about consideration of the relevant and irrelevant factor that are taken into account when a decision is being made, to a larger extent, there is only a thin line between the use of power for the improper purpose and the relevance of the factor considered. There is one case straddle the line between using the power for a wrong purpose and considering irrelevant factor. It would be the case of ex parte Fewbanks. Although the lines between the research of abusive discretion are fuzzy, Public law discretion should not be limited. This was stated in British Oxygen Company case, while at the same time ensuring relevant consideration must be considered, ex parte sign, and irrelevant factor must be ignored, ex parte venables. To summarize, illegality is one of the grounds for judicial review and is concerned about the legal use and application of the public power. It protects fundamental rights of humans by allowing the public to contest the authority's decision made earlier. Through judicial review, the public is able to question that the authority has no legal power to make such a decision. Illegality is one of the grounds for judicial review because the Parliament did not grant the authority as much discretion power as the authority proclaimed.
Hi everyone, my name is Farah Hanim and now I will be talking about irrationality. Under English law, Wednesbury unreasonableness is the general standard of review for rationality of administrative decision. In Associated Provincial Picture Houses Limited and Wednesbury Corporation 1948, the cinemas are allowed to be open on Sundays. However, under discretion of the local authority in this case barred children below 15 years old from attending any entertainment on Sundays. The cinema contended that it is irrational, while the authorities argued that the statute imposed no limits on the condition. Based on the Wednesbury case, Lord Green identified and laid out two limbs of unreasonableness. Firstly, the decision that took into account irrelevant considerations or did not take into account relevant considerations. Secondly, where a discretionary decision was so unreasonable that no reasonable authority could ever have come to it. The definition of irrationality takes the court further from reviewing the procedures which have been made by testing its legality and closer to exchange the court's view of the merits of the decisions. Wednesbury unreasonableness also can be defined as umbrella concept, which includes all the major headings of judicial review. To further understand the principle of Wednesbury, it is necessary to refer to the past cases addressing the Wednesbury principle. An example where a case of the Wednesbury unreasonableness was applied can be seen in Council of Civil Service Union and Minister of the Civil Services, or also known as the GCHQ case 1985. In this case, the employees of the government communication headquarters were banned from joining any trade union. The decision was made based on the potential threat to the national security and enforced using the royal prerogative power. Lord Diplock stated that if a person's private rights or legitimate expectations are affected by the prerogative power execution, then the execution should be open for review. Lord Diplock also observed in the GCHQ case that Wednesbury unreasonableness applies to a decision which is so outrageous in its defiance of logic or of accepted moral standards that no sensible person who had applied his mind to the question to be decided could have arrived to it. In short, a decision falls within this category is a question that judges, by their experience, qualification, and training, should be well equipped to answer. A judge's decision is crucial in deciding a case to make sure that it meets the moral standard of reasonable considerations. Furthermore, in RM Ministry of Defense ex parte Smith 1996, the Ministry of Defense created a policy to dismiss any personnel known to be homosexual. As a result, 4 personnel were dismissed from the armed forces. They applied for judicial review on the grounds of irrationality and violation of Article 8 of the ECHR and the European Equal Treatment Directive. The Divisional Court held that the policy was not so outrageous to be unreasonable. Prior to the incorporation of ECHR into the Human Rights Act 1998, where fundamental rights were at stake, the courts held that the assessment under Wednesbury unreasonableness must be more intensive. Lord Bridge in Baghdadi described it as anxious scrutiny, whereas the Court of Appeal in ex parte Smith 1996 held that more would be needed by way of justification when such rights are engaged. Following the enactment of the Human Rights Act 1998, it was held that where a decision does not engage a convention right, Wednesbury unreasonableness is the appropriate standard of review. In the nutshell, it has been suggested that Wednesbury should remain the test for cases that require greater judicial deference, while proportionality should be the standard used in cases where a more exacting review is required. Moving on now, I will talk about procedural impropriety. Under illegality and irrationality, the protection of fundamental rights through judicial review are mainly in substantive terms. Fundamental rights will now be accessed in much more procedural terms on the grounds of procedural impropriety for judicial review. If the procedures provided by the statute or the rules of natural justice were not added to in the making of a decision by a decision-making body, that decision would be invalid under procedural impropriety. This includes two rules of natural justice, which are the right to a fair trial and the rule against bias. Under Article 6 of ECHR, it requires a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law.
To begin with, the right to a fair hearing requires that no one should be condemned without first receiving a fair hearing. This was highlighted in Rich and Baldwin, where the House of Lords decided that natural justice required the committee to hold a hearing before dismissing the constable. Hence, the dismissal decision was invalidated due to the failure to undertake a hearing. Moving on, the rule against bias requires that a fair judicial decision is made by an impartial and independent judge. This is illustrated in Portal and Measure, where Lord Hope stated that the question of bias should be phrased in the following manner. The question is whether a fair-minded and informed observer, having considered the facts, would conclude that there is a real possibility that the tribunal was biased. This test was later applied in Gillies as Secretary of State for Work and Pensions, where the House of Lords held that a fair-minded observer would have had no reason to suppose that the doctor would not have acted impartially towards the claimant. Hence, the rules discussed above of natural justice under procedural impropriety are essential to protect fundamental rights to a fair trial under Article 6 of ECHR.
Let us look at the aspect of proportionality test in judicial review now. It has been argued that in time, Wednesbury may cease to operate as an independent test in its own right. It might be caught in the pinces of the proportionality test used in EC law and under Human Rights Act 1998. The proportionality test is used to determine whether interferences with fundamental rights are constitutionally permissible. Proportionality considers the aim of the decision maker and whether the means to achieve that objective are proportionate. With the HRA 1998, judicial review is extended to the review of administrative action to determine compatibility with convention requirements. In interpreting the Act, Section 2 requires that domestic courts and tribunals must take into account the judgments and decisions of the Court of Human Rights. Under Section 6, courts and tribunals are public authorities under the Act and are therefore under a duty to not violate convention rights. Furthermore, most convention rights are not absolute and unqualified, but allow states to impose limitations on specific grounds, commonly in the interest of public safety and national security. Restrictions on the exercise of rights, derogations, must also commonly be prescribed by law and necessary in a democratic society. The combined effect of these provisions necessitates the courts follow the reasoning of the Court of Human Rights, and that includes the doctrine of proportionality. Thus, with this Act, proportionality moves center stage in judicial review. Determining whether a convention right guaranteed by the Human Rights Act 1998 has been violated is therefore often a two-stage process. The court needs to establish first whether a right has been impinged on at all, and then if it has, whether the limitation can be justified. The doctrine of proportionality, in the wide sense, is the name given to the set of tests used to establish whether a limitation of rights is justifiable. Proportionate limitations of rights are justifiable, disproportionate ones are not. After the Human Rights Act 1998, the courts do not have to show that the decision affecting the enjoyment of a convention right was outrageous or irrational, but can conduct a balancing exercise to see whether the interference was necessary and proportionate. This new power has been used in a number of high-profile cases. In Ex parte Sims and another, the claimants are prisoners who had claimed to be victims of miscarriage of justice, and they sought to reopen their cases through oral interviews with journalists, by which the prison authorities did not permit under prison policy. The claimants challenged the lawfulness of this, and the House of Lords held that it was unlawful, as the purpose of the interview was, in effect, to help the prisoners gain access to justice, with the eventual aim to demonstrating that there had been a miscarriage of justice. The court held, in the language of proportionality and human rights, that a blanket ban on interviews therefore deprive a prisoner of basic and fundamental right, that of gaining access to justice. Common law conceptions of proportionality assumes that the courts exist to protect individuals and groups from other branches of government. Courts maintain a framework of legal rights which set limits to the freedom of action and legislative and executive bodies. This presupposes that rights and the public interest can be clearly distinguished. Courts stand on one side of a constitutional divide, charged with representing the individual interests of right holders, whereas legislatures and executives represent the collective interests. In A and others, and the Secretary of State for the Home Department, the House of Lords had to decide whether the detention of foreign nationals suspected of terrorism under the Anti-Terrorism, Crime and Security Act 2001 was a disproportionate response to the threat of terrorism. Even in terrorist situations, the convention organs were not willing to relax their supervisory role. Given the importance of Article 5, judicial control of the executive's interference with individual liberty was essential. Although the judiciary must keep to their proper limits, the courts possessed an express role under the Act to interpret legislation compatible with convention rights. On the facts, the House of Lords held that the detention provisions contravene Article 5 and 14 of the Convention. Proportionality is used to determine whether an interference with a prima facie right is justified. It thus only comes into play when it has been established that there is an interference with a right, such as if a person's autonomy has been limited. Such an interference requires a justification because the possibility exists that the policy in question is based on a scheme which fails to specify the right holder's sphere of autonomy in a reasonable way, and which is therefore constitutionally illegitimate. Thus, the point and the purpose of the principle of proportionality is to determine whether a policy is constitutionally legitimate. Therefore, in conclusion, the principle of proportionality provides a structure which guides judges in their task of assessing whether an act of public authority is constitutionally legitimate and that it respects the conditions of democracy and the protection of human rights.
Morning or good afternoon. My name is Rauda Azman, and I will be speaking on the remedies of judicial review. There are three categories of remedies available in the judicial review process: prerogative, equitable, and common law. Remedies within judicial review cases are not compulsory. If an unlawful act is conducted by public authority, remedies may be refused by the court if it is in the interest of the public to do so. Prerogative remedies are provided with judicial review, which acquires from the powers of the Crown to help regulate the public's power. If the remedy is accepted, the Crown will award the act in discreet. Instead of using an ordinary trial process, prerogative writs an ancient concept in which the remedy uses the seeking process by way of summary. From the 12th to 20th century, there have been different forms of remedies a claimant seek in court. As described in the case of Rex and Cowell, Lord Mansfield identified mandamus, prohibition, habeas corpus, and certiorari as writs not ministerially directed, as the case establishes the High Court to grant prerogative writs against the Crown's servants. The majority objectify the judicial review as the method to get hold of the prerogative remedies. Under Section 31 of the Senior Courts Act 1981, it states that an application to the High Court for one or more of the following forms of relief shall be made in accordance with the rules of the court by a procedure to be known as an application for judicial review. This act depicts a means of accessing these prerogatives. The following rules would be established to determine how one accesses these forms of remedies. Rule 54.2 of the Civil Procedure Rules states that the claimant who seeks A, mandatory order, B, a prohibiting order, C, a quashing order, or D, an injunction under Section 30 of the Supreme Court Act 1981 must use the judicial review procedure. Rule 54.3 of the Civil Procedure Rules states that the claimant who seeks A, a declaration, or B, an injunction may also use the judicial review. It questions why would individuals like to seek this court proceeding? According to Section 31, Subsection 4 of the Supreme Court Act, it sets out circumstances in which the court may award damages. A claim for judicial review will possibly include claims for restitution or recovery of sum. Prerogative remedies provide a quashing order, which overlaps with that of prohibition. It is the most commonly used remedy that nullifies or quashes a decision to have no legal effect. Under Rule 54.19 of the Civil Procedure Rules, the court may remit the matter to the decision maker, or the court may quash the public authority decision and tell them to remake their choice. In RN Criminal Injuries Compensation Board, the board cast a resolution to not award compensation, but due to the breach of rules of natural justice, the House of Lords quashed their decision. If any enactment permits, the substitution of a decision will proceed. Secondly, prerogative remedies provide a prohibiting order that often combines with a quashing order. This prohibitory order forbids an ultra vires act or decision. It disallows a public body from taking unlawful action in the future. In the case of a state and trust agencies and Singapore Improvement Trust, the board applied a wrong inadmissible test, which resulted in an error in the decision. This would have led the board to act beyond their due powers. Thirdly, prerogative remedies provide mandatory orders that compel a public body to perform the legal duty imposed on them. This is where the decision maker must act in a particular way to comply with the order. According to Lord Mansfield and R.N. Barker, this prerogative originated to prevent a disorder from a failure of justice and defect of police. If there is only one lawful decision, the mandamus will be awarded. It may occur where this mandatory ordinance lies against the Crown and is used by an official to enforce an action. In the case of Board of Education and Rice, the board denies to use Section 7, Subsection 3 of the Education Act, 1902, and was found improperly addressing the wrong questions to resolve disputes between local education authorities. It was held that the decision was quashed, and the mandatory order to address the correct questions was complied to resolve the issue. Other forms of remedies fall under equitable and common law. Within the equitable remedy lies injunction and declaration. The ordinary remedy of injunctions require or forbids a public body from committing an act that is unlawful. In the case of R. and Secretary of State for Transport, the House of Lords granted injunction disallowing the minister from obeying an act due to the result of causing conflict with European Union law. Although declaration falls under the concept, it is not a form of remedy. It is where a formal statement by the court sets out the legal rights of the parties. It occurs in the case of Gateshead Union and Durham County Council, where a guardian of a child declared the county council for wrongfully refusing children from its schools. The parties have obtained declaration, for it is in their legal rights to have their children admitted into their education ministry. The use of declaration is to resolve disputes as it states the court's view on an issue. Lastly, common law provides damages that arises when suing authorities. It is provided by the Human Rights Act, Section 8, Subsection 3, on the just satisfaction to those who have suffered damages. It is only possible to receive damages in judicial review claims if there is another established cause of action separate to the ground for judicial review, such as breach of statutory duty. All in all, the majority objectify the judicial review as a mere method to get a hold of prerogative remedies.
Based on the discussions above, after the enactment of the Human Rights Act 1998, it seems that the courts are now more willing to review the exercise of any government power that concerns matter where human rights are infringed. However, it is opaque that there are still limitations and grey areas that need to be addressed, and we shall glance through all the points accordingly. Firstly, in the GCHQ case, it was held that there are still some excluded categories of royal prerogative matters which remain outside the realm of judicial review, such as matters pertaining to the signing of treaties, foreign affairs, the prerogative of mercy, and issues affecting national security. For example, in R. L. Ravi as Secretary of State for Foreign and Commonwealth Affairs, the court refused to interfere with the decision by the government not to make representations on behalf of detainees at Guantanamo Bay. Hence, it is evident that the courts have limited jurisdiction in reviewing matters that fall within the excluded categories as specified in the GCHQ case, even when involving infringement of human rights, as this may be regarded as a violation of the separation of powers and an intrusion into the power decision-making sphere of the executive. Moving on, exclusion of judicial review through exclusion clauses can make it difficult for an aggrieved person to lodge a claim. For example, the House of Lords concluded in R. N. Lord, President of Privy Council, ex parte page, that a decision made by a university visitor is not reviewable pursuant to Annis Minnick, where in this case, it was held that any discretionary authority that attempt to deny the right of judicial review will be regarded as unlawful. Besides, in R. N. Registrar of Companies ex parte Central Bank of India, a section in the Companies Act 1985 essentially removed the court's jurisdiction to review. Hence, this may be seen as a violation of fundamental right to a fair trial under Article 6 of the ECHR. Furthermore, the Rule 54.5 of the Civil Procedure Rules states that a claim for judicial review must be made promptly or within 3 months after the ground to make the claim first arose. In R. Gerbel and Wiltshire Council, the court held that a balance had to be struck between the parties where only exceptional circumstances would allow an extension of time to be granted. Thus, this could reduce access to justice, which is a key element of the rule of law. Moreover, the actions of a public body are reviewable, but only limited to matters concerning public and not private law. For instance, in R and Disciplinary Committee of the Jockey Club ex parte Aga Khan, the Jockey Club was deemed to be a private body, even though it has the ability to regulate an important activity. To distinguish, in R and Panel on Takeovers and Mergers ex parte Datafame, the panel was held to be a public body despite the organization was not acting on behalf of the state. In a nutshell, the protection of fundamental rights is not always accessible in some circumstances, as the distinction between public bodies and private bodies is ambiguous.
To conclude, since the enactment of Human Rights Act, the courts are now more willing to review the exercise of executive power when people's rights are infringed. Therefore, when the rights and interests of British citizens are violated or likely to be violated by the act of administrative bodies, there are several avenues of redress available to British citizens, which is the Ombudsman, the Minister, judicial remedy given by courts, which is known as judicial grounds. Fourth, bring the matter to the attention to minister through the member of the constituency. Fifth, complain to the European Court. Among the above said, judicial grounds are the most important yet most common redress for UK citizens to seek for remedies. Therefore, judicial review is becoming important too. As a mechanism for holding the state accountable, judicial review challenges the exercise of delegated state powers. and it also provides a safeguard in relation to secondary legislation. The absence of parliamentary scrutiny for provision during the legislative process can be compensated by judicial review